Yes, good evening to the aspirants of the JCJ Main 2022. Yeah, you are welcome. Karibusana for my class. I admitted. Please, anyone can unmute and read what I posted on the screen. Anyone can unmute and read what I posted on the screen.
People like the evidence does not.
Good evening to the aspirants of JCJ 2022 Main Examination, State of Telangana. People lie. The evidence does not. I unquote. Grissom. And it is he that who made it. Okay, now without wasting the time, and I don't know whether the other trio team is present. Kolikonda, are you present? Motamari, are you present? Okay, now it doesn't matter that I will start my things. Okay, now this is the thing which I made it yesterday, and I said I made the four options here. The A, I have not taken online classes yesterday because I want to relax. My eyes are closed. That is the one, number one. And number two, I did not took a class as I was in the deep sleep. Number three, that is the C, I did not take class as I went to sleep and got up midnight. D, I did not conduct online class yesterday. I slept with a snoring and I got up yesterday midnight. Please send or post me the answer with explanatory note English grammar. I said explanatory note. Okay, because you have already seen my face, but let me stop my video. So I said explanatory note, but the people wrote Sir A, Sir B, Sir C, Sir D. I say explanatory note. That what I said. So explanatory note in the sense, as per the grammar rules are concerned, are you hearing me? Say yes.
Yes.
Good. Because that gives the sense that you are hearing me and I am hearing you, and both are traveling the same boat to reach to the destination. So when you say the simple sentence, especially because when you say the tenses or sentences are 4 into 3, 12. Present, when you present, you will say simple present, past present, not past present, simple present, that is the present simple, past simple, and future simple. When you say the next, present continuous, that is the simple, and the past continuous and future continuous, that is the ing form. Then present perfect and past perfect and future perfect. Then the fourth one is present continuous and the past continuous, present perfect continuous, future present, past perfect continuous. These are the 4 into 3, 12 sentences are there. But when you use the simple past, always simple past goes with the time. So now you will see, I have not taken outline, and it is a present perfect tense. In the present perfect tense, never use the time factor, because when it is completed, just before or 1 hour, 1 year, 1 day, no specific time should be limited there. But I hear the A, I have not taken, that is the present perfect, and they should not have the yesterday, that is the time factor should not be there. That is hence it is wrong. So I did not took. But when I say I did not, the auxiliary verb did, and after that one, the verb should be in a present form. What is the present form of the took? What is the present form of the took? I say, give me the answer. Or you say, pass on.
Take.
Take is the present form of it. And hence that's also wrong. And C, I did not take the class as I went to sleep and I got up midnight. I did not take. Okay, there is a simple past class as I went to sleep, got up midnight. Here also I said the time factor, and hence it will not be the correct one. So the D1, I did not conduct the online class. Either say I conduct, I did not take, or conduct. Of course, they're giving the same way of expression, but the attitude of a person is different when you are saying certain things. And the D, I did not conduct. I, yes, the I is the, what is I? What is the I? In persons. First person singular. So did auxiliary conduct is okay because it's the present form only. Online class yesterday because the time factor is given, and hence the right answer is
Present tense.
D. So whenever that you want to use the time factor, always use the simple past. Don't use the present perfect. When you don't want, the action is more important and the time factor is not, at the time you can use the present perfect tense. Is it clear? Is it
No.
clear?
No.
Simple past. I usually take, I read the newspaper daily, or I read the newspaper. It is a simple present. I read the newspaper. Read, when you say, it is a simple past. When you say I read the newspaper, at the time you have to show the time factor. I read the newspaper in the morning. I read the newspaper at the 7 a.m. I read the newspaper in the evening. Time factor should be there. When you say simple past. But I have read the present perfect. When you say I have read the newspaper, you need to show the time factor. Because I usually read. I have read the newspaper. I have read the newspaper. So when I have and I read, because have is an auxiliary form. I think the being form, that is have, because I goes with the have, but she goes with the has, because simple present is there, and have is the plural form of has. So when the subject is I singular, then you should say have. When the subject is you can say use both singular as well as the plural. And he, she, it, the present form, that is a singular form of the third person, and it also goes with the present. The subject agreement is there, and we can say has. But when you say they have, so I have read the newspaper at the time. Time factor is not the point. Action is more important. When the action is more important, you should use the present perfect tense. When that time as well as the past is important, and you should use the simple past. At least now. Did you get my point?
Yes, sir. Yes.
Okay, sir. Sharath, are you present? Okay. Now, shall I proceed? Say yes.
Yes, sir.
Yes.
Very good. Because sometimes you should have to come there. Otherwise, I cannot move. Okay, let us come to the point of what is the sequence? Examination in chief, or re-examination, or cross-examination? When you see the sequence, I believe that we read it in the MCQ. What is the perfect sequence? Proper sequence? Witnesses should be examined. So what will come first? Anyone?
Chief examination.
Examination in chief or chief examination? But when you see the right wordings,
Examination in chief.
yeah, when you see the right wordings, Section 137 of the Indian Evidence Act 1872 says examination in chief. That is the right wording. So Section 137 clearly mentions the examination of a witness by the party. Who calls him? Who calls the witnesses? Anyone?
Judge, maybe court maybe calls him.
Okay. You are right. But the point is, it is witnesses both in civil cases and criminal cases. Answer.
Criminal cases, sir.
Why not civil cases? Don't you see the civil cases, the witnesses are there? It is for the both. But in criminal cases, who will move the trial?
Prosecution.
It is the state.
Prosecution, state.
It is the prosecutors. Either APPO or public prosecutor, whatever it may be, the designation is by the state.
Sir, I have one question.
Yes, please.
Why in criminal cases it is always stated that state versus XYZ? Why not the name of the person versus XYZ?
If it is a private complaint,
No,
then
I
name
know.
of the
If
person will be appear.
no, I said if any rape happens or if any murder happens,
It
why
is
it is
a
always
public at
state?
large will be suffered. No
Yes,
individual
yes,
would be
yes.
taken on. The
Public
state
at
come
large
to the
will
rescue
suffer.
of the
Yes,
complainant.
yes, correct.
The state come to the rescue of the complainant.
It is public at large, which is at which
That's why we
affects.
said the public offense. Public at
Yes,
large will be suffered.
yes.
In the same manner, even public nuisance also. In the
It is
same
not
manner,
suffered.
even a
No, no, it is
defamation
not.
also.
It is not suffered. It is public at large will suffer.
Yes,
Suppose
public
comes.
large it will be suffered and got victimized. So that was the reason the state will move it. So when the state move, the state will summon the witnesses and the state will ask the witness in the
Yes.
beginning. And the person who calling the state counsel, here is the state, in the civil cases, the counsel for the plaintiff. You
Yeah,
will
yeah.
plaint. Or we can say the counsel will come and call the witnesses, and the counsel make the examination in chief.
Examination chief.
And how it can ask? Again, it is on the oath.
Yeah.
If it is the witness is a Christian, and the oath will be taken
Taken.
on which
Yes.
scripture, mythology, holy book.
But sir, now they stop taking on holy books. Now they
Yes,
have
yes.
a printed. Now there's an oath act.
Yeah, earlier it would be there, but now
Ah,
just
but
only words.
that zamana is gone now.
Okay.
Bhagavad Gita, Quran, Bible, all this is gone now.
I am giving it earlier used to the Bhagavad Gita, Quran, Bible. These are the
Yeah.
holy scripture would be there. But now,
No.
what are the wordings? Anyone?
I so and so do.
God, in the name of the God.
No, God का नाम ही नहीं आएगा उसके अंदर.
Okay, okay.
Whatever I state
So-and-so
truth, but nothing else truth.
going to tell the truth, but nothing else than the truth
Yes.
that I am going to reveal.
Yes. Yes.
These are the certain wordings are there, and that will be uttered.
Yes.
Then-
It is printed. Normally, it is printed and kept in the witness box itself only.
Suppose if we could read about that language.
It's a simple English language. It's written in regional language. If you're in Bombay, it's in Marathi and in English. If you're in I don't know which other states, it's
If
that
suppose
vernacular
you could
language.
not read it, then it will be recited.
Then it will be recited. Then the
Yes. So there he will say, yes, the witness will say, yes, sometimes now that your name is and so forth. Then you tell me what happened to that particular offense. You tell what do you want to tell. So that man will reveal it at the time by Reshma or somebody
It is-
else. I could hear your household talks. Please mute. Please mute. When you speak at the time, you unmute it. Okay, shall I proceed? Okay, now come to the point is, so they will make it out. Here they say, the examination of your witnesses by the adverse party shall be called, of course, here first is, counsel will make it out. For the civil cases, counsel. For the criminal cases, state. Okay, next up they say, the examination of the witnesses by the adverse party. Adverse party means, who is the adverse party?
defendant,
Opposite party. But
defendant
say
or
in the civil
respondent,
case, the defendant, and
Defendant
in the criminal
or
case, the accused person.
accused,
That you are
accused.
arguing. Is it clear?
Yes.
So now that is the adverse party shall be called and he make the cross examination. So in
Yes.
137 they say the first examination chief and the adverse party will make the cross examination.
Cross examination.
And the examination of the witnesses subsequent to the cross-examination, if at all, if anything is there by the party who called him, shall be called re-examination.
Re-examination.
That means re-examination and examination will be done by only one person. Am I right?
Yeah, correct.
That is the standing council or the state.
Yes.
So these are the sequences there. And who said 137 section says? And even the section 138 also clearly mentions the sequence should be followed. What is the sequence? Examination chief is the first. Second,
Cross-examination.
cross-examination. Third,
If you want, then
Re-examination.
yes, re-examination. If there is a possibility would be there. Even, of course, there is another point also there. With the permission of the court, again the cross-examination can be done.
It can be done.
Okay, that is the sequence. Suppose if your adverse party is asking a certain question, which is said to be the leading question, then what do? Objection, my.
Then you object.
What do you say? I don't think that now they are saying my lord.
No. Now you don't use the word my lord. In lower courts you say sir or madam, but in high courts still people call it your lordship, your ladyship.
Yes. My can you say His Excellency or
My
Her
lord, the word is
Excellency?
gone. And even the word your honor is been not used now.
Okay,
It's
can
mostly
you say
used in
Her Excellency in the apex
No, you
courts?
can no, your ladyship.
Okay. That depend upon the state to state or the uniformity.
No. It's a bar council rule.
It's a bar council rule. So what is the
Yes.
appropriate word?
Your ladyship for ladies, for female judge, your lordship for the male.
Okay.
And for lower court, and that is for the high court and supreme court.
Yeah.
For lower court, it is madam and sir.
Okay. Is it clear to all the participants? Is it clear to all the participants? Say yes, sir.
Yes, sir.
Why you are losing the money? You don't lose the money if you want to say yes, because that is the thing which made me. And I invited madam, but I don't know whether madam is present or not. Yeah, let me say it. No, madam is not present. Okay. Her name is Kaur, Deepika Kaur. Of course, I asked her to say, madam, if you are free enough that you can join with us, I would like to introduce to our students. If you could see Deepa Gagan Kaur in the list, you please remind me. Okay? Okay, now next, let us see that. What are the stages in examination of a witness? Now I already made it clear. Tell me the stages.
Examination in chief, cross, re-examination, or objection, anything if you have.
It is given clearly in the section 138 of the Indian Evidence Act.
Indian Evidence Act.
The stages: examination chief first, cross-examination next, and re-examination third. So, what is the examination in chief under Evidence Act? And who will do it? Answer. It is there on the screen also. Or you can use your own words.
The person who's
In the criminal case, it's the state. In the civil case, the council.
in civil case, the council will do it. Who has filed the complaint.
Yes. And they will make it the witness. Why the witnesses should be examined? One question. Okay. Anyone? Why the witnesses should be examined?
To ascertain the facts. What he has stated, what he has written in the FIR or charge
there
sheet.
in front of the
Court,
judge, magistrate. And then immediately magistrate will record
the sentences, information, whatever is stated.
all the thing what is said by the witness.
Yes. Whether
And it will be signed
matches or
by
doesn't
both the
matches.
parties. And here the
Yes.
party is witness as well as the presiding officer.
Yes.
Of course, it depends upon the language, again the court language.
Yeah.
In the
But
court of
even-
records, it should be in English.
But even during the cross-examine, the accused has a right to remain silent on certain issues.
Okay.
But it doesn't mean that is accepting to certain things.
So in Telugu, we will say,
I don't know
Maunan
about
is
Telugu.
Ardhangikaram, means
No,
silent is
I-
half consent.
No, you have a right to remain silent during a cross question.
Okay.
You don't need to answer, but
Okay.
it doesn't mean that you have accepted to that question.
Okay.
You reserve your right not to answer that.
Okay. Can you say
can tell
hostile?
the court. Yeah.
Can you say hostile?
No. Hostile is different. Hostile is where you're surrendering yourself. Okay, now something which you have done, you may say, okay, earlier you were in the other party, now you're coming to the X party, now you're coming to the state. Okay, I've become a hostile witness now.
Yeah.
This is not hostile witness.
In
This is not
most of
hostile
the
witness.
cases, criminal cases mostly,
Yeah. Yes.
hostile
You not
comes
become
only
hostile.
mostly in the criminal cases.
Yeah.
And what is the statement which is recorded by the witnesses at the time? The police record, is it a 161? The statement. Police record the statement in the witness because you told that in a particular case you saw that thing, but now you are saying I did not know it. What is that statement recorded by the police? Under which section they will record it?
161 statement, sir.
Is it 161? That's why I'm asking you.
Yes.
Okay, now let us see can cross-examination be done again? That's the question. Yeah,
cross-examine can be done, but with the permission of the court.
Yeah, section 1214, subsection 3 clearly says of the Evidence Act.
But 214 section under sir, Evidence Act lo only 167 sections totally.
I don't know why they say it is the CRPC, because it is said. You are right. Okay, let me make the correction for that one. Examination by explaining that where a witness has been cross-examined and is then examined by the gathering and who calls him, such examination will be called a re-examination. And of course, there is some mistake is there. Because
yes, okay.
In the cross-examination, the CRPC also say in criminal cases. I don't know what provisions will say in the CRPC.
1970 was.
But let me make the clarification later. Srividya, if you have the clarification, you can give me the CRPC. Any provision would be there in the CRPC or CPC which says about the re-examination or examination. Please check it. Meanwhile. So I already told you what are the 3 stages that again we need not to make it out. And first one is the examination in chief, next is the cross-examination, and the last one is the re-examination. Is a cross-examination is a mandatory? Is the another question. They say mandatory. 137 section, there is no 137 section in the Evidence Act?
Yes, sir, undi.
Mari unnappudu somebody has made the objection, no? Acha, 214 is objection.
Yeah, 214 is objection.
Yeah, here they say 137 of the Indian Evidence Act 1872 clearly mention examination of the witnesses by the party who calls him and shall be, say the word say shall be, call his examination in chief, of course. And in the re-examination, again, section 137 of the Indian Evidence Act, the examination of the witnesses by the adverse party shall be called is a cross-examination. Okay, adverse party will be given such a right. Then come to the example of the cross-examination is concerned. How most of the witnesses will be confused in the cross-examination. Am I right?
Yes, sir.
The reason is, suppose if you have seen the murder at the 5 a.m. in the morning. So in the cross-examination, sometimes the adverse party will ask, and you daily get up at 7 o'clock. He say yes.
Sir, there is a provision in CRPC, sir.
Okay, tell me, please.
Section 217, recall of witnesses when charge altered.
Okay, charge alters at the time.
Yes, sir.
Oh, at the time that he will be called for the re-examination. I mean, yes, both the cross-examination.
Yes, sir.
Okay. Thank you very much. Yes, Satish Narsati, I appreciate. Somebody should have to come for the rescue because it is a learning process. And learning, sometimes I can learn from you and you can learn from me. Am I right?
Yes.
And the learning is a circle. It doesn't have its ending.
Yeah.
Okay. Now, he said, you get up at 7 o'clock. He said, yes. When you get up at 7 o'clock, how could you get up on 5 o'clock at the time? Sir, I
He
was
can
going to the
nature call.
a trip or
Nature
to
calls, yeah,
Hyderabad
wrong.
or to somewhere and somewhere. Hence, it is forced me to get up at 5 a.m. Because that way they can ask, because sometimes they will not be in a position to give the answer that such a question will be going to be asked. So, didn't you testify that you saw me with my husband at the park on Sunday? A question asked. At that, he did not hit him. Witnesses say, yes, that's what I said. So, sometimes they will ask the question, did you wear the spectacles? And whether light is sufficient to see? Because 5 a.m. And what about the now 5 a.m.? Is it a dark or is it a very much sunny day?
Dark, 5 a.m. dark
It
nowadays.
is generally in the dark. In Tanzania, up to 6:30 also, you could not see the people outside.
As it is,
So
उधर को
much
लोगों को
dark.
दिखते भी नहीं.
Of course, depends upon the season. Again, am I right?
Yes.
So they will ask the pros and cons in the re-examination. So examination chief is a naturally it will be done because your party only will does it. And here I have given a lot of discussion here. When a party examines the witness who is called by him, it is called the examination chief. This is the first thing of your whole examination process. On once in oath is confirmed. Of course, now the oath is not over there. Only the verbal wordings are there, recitation. And a sophisticated chief examination is capable of establishing the plenty of objects. Questions amounting to the leading ones are not asked in this kind of examination. And the competency of the witness is one essential which is to be kept in mind, and his testimony must be reflect the relevancy. Yes, capability of the witness is also an important factor. Can an instant will be a witness?
No.
Means a sound mind in the sound body with all the senses working and should be a witness. Can a dumb will be a witness?
No.
Yes.
Why? He cannot write it. He can write and show.
You can write it. Sorry, you can write it. Yeah. Sorry.
And especially the person, those who are arguing, and all three senses should be good. What are all the three senses? What are all the three senses? Perfect. He could speak,
Eyes,
could
ears,
listen.
tongue, sir.
Eared,
Eyes, ears,
Eyes, tongue.
mouth.
three
Yes,
senses.
three senses. He could speak well, articulate well, good, and he can write, he can see, and he can listen.
Ear.
Okay. Yeah.
Yes, here. So there must be an adherence and the rule named a golden rule while preparing for this examination, and he said that there must be clarity, outline the question shall be prepared, proper phrases shall be utilized, relevant portions have to be given, primacy of the flexible question shall be taken the discourse too when they are making the examination in chief. Now anyone can unmute and read the cross-examination. I repeat, can anyone unmute and read the cross-examination?
This examination plays an instrumental role in this examination of witnesses and considered as one of the most crucial methods in determining and obtaining of truth. 10. It is preceded at instance of adverse party 11. An attempt is made to check veracity as well as credibility when it comes to a witness's statements and his testimony and his checking. It is the primary aim of the function. Questions beyond to the facts can also be inquired about the during course of this examination, but misleading ones are not permitted to be asked.
Yes. This examination plays an instrumental role by the adverse party, while examination of the witnesses and considered one of the most crucial method in determining the obtaining the truth. And you read that 10 also because it is a footnote. Okay, no matter. It is presented at the instance of the adversely party can make the cross-examination. And sometimes he will ask such a question, which is said to be the leading question, which is having the answer in his question only. At the time, the opposite counsel will make objection. At the time, the judge will make it out. Either, say what the judge will make it out. What the judge will say. Why? Venunath,
Yeah. Tell me.
objection is sustained or
Overruled.
objection is overruled. If sustained, he is not supposed to proceed.
Proceed with that.
If it's overruled, he can.
Stop it.
Stop it. Or no, you can continue it.
Overrule.
Whereas overruled, he can continue it.
You can continue it.
Yes. Questions beyond the facts can also be inquired about during the course of this examination, but misleading ones are not permitted to be asked, and the leading questions will not be supposed to be
Cannot be
asked.
asked.
So this right of the party to cross-examine a particular witness is not just merely an ordinary right, but is found recognition in the principle of the natural justice too. Always give the other party a chance to listen and hear and argue and ask. Since perjury itself is a crime in a court of law, this
Yes.
requisite of the cross-examination plays here a significant role in the truth discovery. They want to ascertain the fact, discover the truth, find out what is the truth. If adverse party does not indulge in this process of the cross-examination, cross-examining the witnesses, this leads to an inference being drawn that the adverse party has accepted the truth of the made statement and leaves no room for any subsequent grievance being raised if this is not conducted. Sometimes, even the adverse party will say, cross-examination, they say no, because he knows that there is nothing we can obtain it from him if he knows it. But in certain places, definitely he will make the cross-examination. Am I right?
Okay. One question I have.
Yeah, please.
If a person is fighting his own case,
Yeah.
how can he do his own examination in chief?
Yeah, that is again the question comes over there. If you are arguing your own case, at that instance, it is you have to give the chief examination. And you will only the cross-examine.
I know. Yeah, that's correct.
Am I right?
Yeah. Correct.
No one will be a judge of his own case.
His own case. That's correct.
For instance, you take the medical practice. He's a beautiful surgeon, fantastic surgeon.
But he can't do his
No
own
doubt at
body
all.
operation.
But he cannot do his operation his own wife or children.
His hands and legs will shake.
Why? Psychological feeling would be
Psychological feeling. Yes.
there. Psychology plays a very important role.
Important role.
If you think you are strong, I'm sure that you are strong.
Mm.
But if you think that you cannot in your life.
Yes.
So that is the psychological fan. Half of the people in the pandemic died because of the
Psychological effect.
psychological effect. They died.
Yes.
If you consume a pill which is of a sugar content, thinking that it is a curative given by somebody else, even
You will not die.
automatically you will be cured,
Good.
because the reflexive system in the body will work.
Yes.
And I gave an example also in my student. What is the best way to give the minimum pain for the killing of a person, for the sentence to death?
Psychological kill him.
Mode.
Psychological kill him.
No.
Make him a dead person.
There is a capital punishment is there in India.
Mm.
What is the mode of giving the capital punishment?
Hanging.
Hang to death.
Yeah.
A nose.
No, hang
around your
until
neck.
death. No, one minute. Hang until death, not hang
Yeah.
to death.
Yeah,
Hang until death.
Yeah. Yeah,
Yes.
that is the wording they used it.
Yeah.
Hang until the death.
Yeah.
The more specifically.
Yes.
Strangulation, a noose will be around the neck, and you will be on the gallows. There is a place is called gallows, Gallow.
Yeah.
And
But
the
normally,
lower part
but
will be removed,
mm,
and you will be
mm,
hanged to death till the
yeah.
death.
But in
That is the
English,
minimum pain
yeah.
will be there.
But in
But
British English,
yeah,
gallows means jail in British English.
but here
But
I will show you
in
what
Indian
is
English, it is
gallows.
different. Yeah, in Indian English, it is different.
I will show you what is gallows also to make it.
I know.
Yeah, meaning and images. A wooden structure used especially in the past to hang criminals as a form of execution,
Execution.
as a punishment. So you mean by gallows does look like gallows? I want to say images. Yeah, there are
I said,
images are here.
I
Did you
said,
see the images?
if you look into the British English, Queen English,
Yeah,
I'm not
yeah,
talking about normal English. I'm talking about Queen English.
Okay,
There's a difference between an ordinary man English and a Queen English.
okay. Appreciate. So now let us come to our point. Yes, that is the and
Sir, one question.
Yes, shall I proceed?
Yeah, I have one question for the participants.
Yeah.
Look, I think most of them have cleared the exams of this judiciary something all.
It is
Now,
only the screening test.
Okay.
MCQ, multiple choice questions.
How many chartered high courts do we have in India?
Chartered high courts, because every state doesn't have the high court. That much I can know.
But each state has a high court, except northeast states. You leave those northeast states. I said chartered high courts.
Yeah, because I don't know the wording chartered here. Because sometimes the one court will work for the two states and union territories.
No.
Once again, please.
Huh?
Can you repeat the question once again?
Chartered high courts in India.
Means how many chartered high courts in India? That's your question.
Yes.
Okay.
24.
No.
3.
Oh, no. No
Total
guessing.
high court, huh?
Total high court you have in each state. You have each and every high court, including Jammu and Kashmir. I'll tell you the answer. No, forget. We have only 4 chartered high courts in India.
Okay.
Only 4. One is Allahabad High Court, Bombay High Court, Calcutta High Court, Madras High Court.
Madras High Court, yes.
These courts have extraordinary criminal jurisdiction under Section 474 of CRPC.
Okay.
These are extraordinary courts which are there right from the Britishers period. These courts. And all other high courts, let it be Andhra Pradesh, Telangana, other high courts, they have all come after the post-independence.
Okay.
These four high courts have come prior to independence.
Yeah, appreciate. Please note the point, even the section also. CRPC, what
474. 474.
474 CRPC.
Chartered high courts. This is
very good. So now, as we made it clear, because the cross-examination, what are the things should be there, how we can make it out, and what are the points should be asked over there. The leading question should not be asked. And however, if adverse party is willing to cross-examine, but reason best known to the court is not allowed to do so, the said evidence is rendered to be not taken consideration at all. So a relevancy should be given over there. Of course, the counsel make an objection, then the judge will decide to overrule it or to sustain it. Then the re-examination is concerned. Yes, again, the same party will make it out. When any matter gets aroused during the course of the cross-examination, if a new point has come into the picture, and this kind of examination provides a stage for explaining those matters and is usually confined to such matters only. If a clarification would be there to make it very much clear to the judge, at that instance, the counsel make for the re-examination. So attempt is made to clarify the expressions used by the witnesses during the course of re-examination and cross-examination. Additionally, new matter also be brought up, but with the due permit taken from the court, and then again the adverse party gets conferred with the liberty to cross-examine those points. If at all, new points have emerged over there. At the time, court had given the permission, then the adverse party again got the chance for the cross-examination. So, in the simpler terms, objective of the chief examination is witness examination under the oath. Of course, now oath is not there. To cross it to reveal the truth, and that of the re-examination, removing the vagueness if it is there. In so far the leading questions are concerned, they are not to be asked in the chief and the re-examination unless court permits them to be asked, but are capable of being asked during the course of the cross-examination. In the cross-examination, definitely the objections will write by the parties, the counsel, and then the judge will make the discretion to overrule it or to sustain it. So in this way that we can say cross-examination and examination in chief and many other point. Again, here I give the, but let us see if any case law is there under the particular point so that we can make it out. Because they are given only the section, but I have mentioned some case law also here. Let me check it and we go further. Yes. Who can cross-examine? The party who has a right to take part in any inquiry or trial can cross-examine the witness or witnesses. In B.S. Balaji versus T. Govindaraju, there is a case law where one of the managing director of the firm had borrowed money on behalf of the firm in that capacity without the consent of the other managing director. The latter, being an adverse party, had the right to cross-examine the former. So, let me read it again. Where one of the managing directors of a firm had borrowed money on behalf of the firm in that capacity without the consent of the other managing director. Now the first question comes over there. Can the managing director borrow the money from the firm without the consent of the other managing directors? Anyone?
No, sir.
By the fictitious name, by any other person's name? Yes, that is again. Here they says, being an adverse party had the right to cross-examine the farmer. Means the person who has taken the money from the firm, the director, at that time a director, managing director can be put for the cross-examination. So that is the, anyway, that what I want to say is a adverse party can definitely will ask the questions in the cross-examination. That's what I want to say is. So let us see the range of cross-examination. How much range would be there? The range of cross-examination is unlimited. The only circumscribing means limits being that it must relate to the relevant facts. Yes, that is about the facts only we can make it out. By section 146 to 150 of the Indian Evidence Act, the legislator had tried to give very wide power to the cross-examination to help him in finding out the truth in oral disposition laid out before the court. So in the course of the cross-examination, a witness may be asked the question, number one, to test his veracity. Number two, to discover who he is and what his position in life. Number three, to shake his credit by injuring his character, although his answer might criminate him or expose him to penalty or forfeiture. But in certain places, we cannot ask the character of a person unless until it is relevant to the case law. Am I right? Participants,
Yes, sir.
Yes.
are you there?
Yeah, very much.
So, a wide range is given by the adverse party. Under which section to which section? Just now I read it. 146 to
146 to
150.
150.
150 Indian Evidence Act has given it to test the veracity of the witnesses, to discover whether he or she, his position in the life, and even to shake his or her credit by injuring his character, although his answer might incriminate him or expose him to penalty or the forfeiture. In certain respect, the wide range is given over there. Then they have given the omission to cross-examine. If the adverse party wants, he can just omit it, the cross-examination. Am I right?
Yes, sir.
Yes, sir.
Because he knows that this we cannot extract the truth from him, and he's not that worthwhile witness. But when he's not worthwhile witness, that's why it is introduced. Okay, it is by the other party who introduced the witnesses to see whether that witness is very much useful to him or not. Suppose the witness is a habitual criminal, then what would be your role? Can such a witness will be relied?
No.
When it is known that he is a habitual criminal or he will be hired to be witnesses for the money, then his witnesses will be outrightly rejected. When a party has declined to avail himself of the opportunity to put his essential and material case in the cross-examination, it must follow that he believed that the testimony given could not be disputed. When he said that whatever that he said is not disputed over there is no question of, again, extracting the truth from him. So at that time, he will decline for the cross-examination. Okay, now cross-examination of witnesses and co-accused or co-defendant, where two prisoners are tried together, one given evidence affecting the other prisoner has a right to cross-examine. Yes. Evidence of the witness is examined in the defense on behalf of one accused and cross-examined on behalf of another accused is admissible when two witnesses are there for the two prisoners. Who is the prisoner here? Prisoner is not a jailer. A person who is imprisoned in the prison is called the prisoner. Am I right?
Yes, sir.
So at that instance, they will say admissibility would be there, how it can be made. Where evidence produced by the partner defendant was found admissible against the other co-defendant partner. When the co-defendant partners are there, it was held that the co-defendant have a right of cross-examination of such defendant partner. Yes, co-defendant have the right to even the cross-examine such a defendant partner. Okay, now let us see any other case law. No opportunity for the cross-examination. Also, okay, now let us see what is the time for the cross-examination. Power of court to limit the Privy Council held that the judge has always the discretion as to how far the cross-examination may go and how long it may continue. A fair and reasonable exercise of his discretion will not generally be questioned by an appellate court. That means if he is too much lengthy would be there, then naturally the judge make an objection. So delayed cross-examination or delayed cross-examination does not affect the credibility of the witnesses. When earlier version of such a witness was found to be consistent with other evidence and conviction could be based on such evidence. Generally, whenever you say now witnesses, the same wording should be repeated, even that it is trained by the council. Am I right?
Yes.
And as it said, no, when the confusion state would be there, be silent.
That's the best thing.
That is the best method.
Instead of opening and uttering words, remain
Instead of
silent.
uttering, when you utter word, that cross-examiner, that adverse party, he will catch you definitely. In one way, in another way. So
Earlier
Section 138 of the Evidence Act and Section 311 of the CRPC. Provisions of the Section 138 of the Evidence Act and Section 311 of the CRPC are complementary
to each other.
Not conflicting with one another. So please check it, what the Section 311 says. And they say complementary it is.
Yes.
Means
They both relate to each other. They both.
But not contradictory to each other.
Yes. Yes.
So now let's see the hostile witness. A witness who is antagonistic to the party calling them and being unwilling to tell the truth. May have to be asked the leading questions. A hostile. Somebody is speaking. I could hear their voice. Okay. A hostile witness is also known as the adverse witnesses. Oh, this is the first time I heard. I only the hostile witness. But he also be known as adverse witness or an unfavorable witness. It's a common terminology. But adverse witness is a new terminology to me. And he is a witness at a trial whose testimony and direct examination either openly antagonistic or appears to be contrary to the legal position of the party who called for the witness. I told you, in written statement of 161, he said something. But when you ask the witness in box, he get the contrary view. And sometimes we can say it's a hostile witness, or we can say adverse witness, or an unfavorable witness. An unfavorable witness. So how many terminologies are there? How many terminologies are there for hostile witness?
4 terminologies.
4 terminologies.
What are they?
Hostile witness, adverse witness, unfavorable witness, antagonistic witness.
Yeah, because his antagonistic way that he is good.
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
Jai Hind.